Well, good morning. My name is Leon Jones, and the clicker is not working, so she's gonna flip it for me. And so I'm with Big Rock Legacy Law Group, and you can flip it. And this is our mission to help families, individuals, and businesses across Arkansas build generational foundations for their loved ones by providing quality service, exceptional representation, and sound advice. You can flip it. And this is my why. My wife, Tori, my daughter Sydney, and my two daughters Bailey and Olivia. So that's my why. My son is not up there. He's 24. He doesn't really care. But that's my why every single day. You can flip it. All right. So show of hands. I want to see who can get this answer right. What's the percentage of people in this room who are going to die? 100%. 99. You're not going. Oh, well. You're not. Gotcha. Okay, well, hey. So we got about 97% of the people in this room are gonna die, right? For those other 3%, I'm not talking to you guys. But have you ever considered what would happen to your estate when that day does come? And how many people outside of your family do you want knowing your financial situation? So we're gonna talk about public versus a private estate plan today. You can flip it. So the likelihood of you dying and leaving the estate is 100%. We just talked about that, right? But the question is, do you want a public or a private estate plan? You can flip it. So do you want your financial matters in the hand of a judge? Do you want to have your loved ones who are grieving have a seamless transaction of your affairs? So a quick story, 2 stories as a matter of fact. Well, actually, I'll wait to the end. Go ahead, you can flip it. And a public estate plan, the petition is filed in the county where you died. Judges make the decision on when and how your assets are disposed of. Creditors have access to your estate plans and your funds, and any person with a computer can get your information. So if I know your name, and I've done this because I do the search all the time, I can type in your name, hit enter, and I can figure out when you died, what assets you had, everything that you own, where they were located, and everything online. Next question, next slide. Okay, so ask yourself, do I dislike my loved ones so much that I will put them through a 9 to 18 month public ordeal and cost them thousands of dollars? So how many people can say yes to that? Exactly, nobody. We all love the people in our lives, right, that are close to us. And so we don't want to put them through this. Next slide. So private estate plan, you control how it is distributed. Your loved ones don't have to go to court. There's no will to probate, so the assets are disposed of under your control from the grave. And the loved ones have time to grieve without glaring eyes of creditors. Next slide. So what's the solution? Come talk to me. So two quick stories. Number 1, a public plan. Mom and dad brought the kids together 3 years before mom died and said, hey, here's what we want to see happen with our estate. Mom died. A year later, dad put together a will to basically solidify what mom said. Dad dies 2 years later. 4 years later, they're still fighting. 4 years later, they're still fighting. And guess who made more money on that distribution of the estate than anybody else? You're looking at it, right? Because they had to pay me to litigate a will contest even after mom and dad had sat down with the children to say, this is how I want it to be distributed, and they put it in writing. That happens every single day. Scenario number 2. Lady comes to see me, 92 years old, vibrant. I mean, just the spark of life. Enjoyed meeting with her. A year later, she's gone. But you know what we did the year before? We updated her estate plan. And we made sure that her rascal nieces and nephews that she didn't like were not in the estate plan, right? And so all of the funds that she had left in her estate are allocated according to her wishes. And I got an angry phone call from one of the nephews, and I said, well, your aunt didn't want you to have anything. No, I didn't say it like that. I didn't say it like that. I was just playing. But what I did tell them was that it's private. It's private. And the trustee is not giving me permission to release any of that information. So the choice is yours. You can have a public estate plan because guess what? You're going to have an estate plan, whether it's public or private. So you have to choose. And if you haven't seen your estate planning attorney in the last 12 to 36 months, trust me when I tell you, it is not up to date. You can sit here and tell me all day, oh yeah, I did it 5 years ago, we're good. No, you're not good. And I can promise you you're not good because laws change every single year. And if you don't update your plan on a regular basis, 12 to 24 months, as you get older, it's going to fail. Any questions?
Question.
Yeah.
So if I'm reading between the lines here, if you have a will, it can be challenged, but if you have an estate, it can't be challenged.
So you said it almost correctly. If you have a will, it has to be probated, which can create challenges. If you have a trust, it cannot be probated. It will not be probated, and therefore kept secret, and we can do everything in my office.
I think my question was things off of David basically answered it. I was just wondering, like, okay, so if you have an estate plan and you pass away, does it go to a judge at all?
If it's a trust, it does not.
How does it start being
Administered? Very good question. So a trust is administered by the attorney or the attorney who drafted it or another attorney. And you go to their office and they read through the trust and they say, okay, so-and-so is supposed to have this, so-and-so is supposed to have that. We get the trustee affidavit done and we start dispersing the funds.
And so it doesn't have to go to a judge.
It does not have to go before the judge.
So if the trust has an executor or executress, does that the attorney still have the same role? Or does that
Pretty much, because depending on how legal some applications, so the trust the trust that I'm administering has some legal complications in there, so we need an attorney to help administer it. But if it's just a simple trust that has a house that you've already transferred before the person died, but there's some other funds to be dispersed, if the trustee has access to it, they can just disperse it. And last question.
Sorry. So if you have life insurance through our risk advisor,
Mm-hmm.
Does that go into the trust? Like how?
It can. It's up to you. You can put life insurance in there. You can name life insurance as the beneficiary of your trust. Right.
And you can make the death benefit. You can make the trust the beneficiary of the death benefit.
Yes.
Yeah,
That's it.
Yeah.
You can do it as primary or secondary.
Yep.
Yeah.
So a lot of times your spouse is primary, but then the secondary is the trust, so it's distributed properly to minors.
Yep. I have to stop because someone else is coming behind me. But let's do it one-on-one.